Sir Gary Apsner.
Before this hearing even properly begins, there's already a subtle tension in the room. Courtrooms often look calm on the surface, but behind every case is a real conflict. Tenants, landlords, neighbors, financial stress, and sometimes years of unresolved disputes. Today's docket with Judge Simpson moves quickly, but the cases themselves are anything but simple. We're about to see multiple property and tenancy disputes unfold, each one showing a different side of how civil courts handle housing conflicts. In situations like these, the court's job isn't to settle personal arguments, it's to enforce legal obligations. That means documentation, timelines, and compliance with local housing rules matter far more than emotions or personal narratives. Judges like Simpson operate on procedure, proof, filings, deadlines, and whether the law has been followed. But here's where things get interesting. As we move through this session, you'll notice that not every defendant fully understands the legal system they're standing in. Some people arrive prepared with lawyers and filings. Others walk in alone, unsure how to respond, hoping the judge will guide them through it. And that gap between legal knowledge and real life is where many courtroom dramas actually begin. So keep watching closely. Each case today reveals a different type of dispute. Property maintenance battles, eviction claims, financial arguments, and accusations of deception in court filings. The real question is this: who actually has the stronger legal position once the facts are examined?
Ephraim Jackson? There's no response. Would you like to take a default?
I would, sir.
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
All right, go ahead. What's your claim in this case?
This is the termination of tenancy based on the facts that the property had been uncertified when a lease was initially drafted. The court this is our second or third time on this case. As the court directed, I had all the previous monies that were sent to paid by the defendant sent back to him, and his check is cleared. And you wanted us to evict essentially the other roommate in this property. And Mr. Mentha was going to be online. I think he may have had to leave for work, but he told me that person's also gone. So the two prereqs you had, or the three, proof of the lack of certification, payment of the back payments, and the vacancy of the third or the second roommate have all been accomplished, sir. To the best of my knowledge, Mr. Jackson's appeared a couple of times, so I don't think he's a minor, incompetent, or in the military. And again, it's a termination, so we're not asking for any money, just the property back.
Judgment to the plaintiff, that's by default for possession. No redemption amount. Writ issue 10 days. Thank you.
Thank you, sir. Have a great weekend. Thank you, sir.
This moment might feel quick, but legally it's extremely significant. What just happened here is known as a default judgment, and it's one of the fastest ways a landlord or property owner can regain possession of property in civil court. A default judgment happens when the defendant either fails to respond properly or doesn't contest the claim in a way the court recognizes. The judge essentially says, since there's no legal opposition, the requesting party wins the claim. In this case, the landlord wasn't even asking for money damages, just possession of the property. That distinction matters. When a case is strictly about possession, the court focuses on whether the tenancy should legally continue. Once the judge determines that the requirements have been met, notice given, procedural rules followed, and no valid challenge presented, the court can grant possession fairly quickly. You also heard the judge mention no redemption amount. That means the tenant cannot simply pay money to stay in the property. Instead, the ruling focuses purely on regaining possession. The 10-day window the judge issued is also standard practice. It provides a short period for compliance before enforcement actions like eviction orders can move forward.
You do the same. Lawrence Carroll versus Patrick Cox.
Good morning, Your Honor. Dan Troik appearing on behalf of the plaintiff, Lawrence Carroll.
Plaintiff Lawrence Carroll here.
Patrick Cox, I'm here.
All right.
Laura Cox is
I
here.
have had, so that the parties are aware, I have had the 4, looks like, cases, municipal civil infractions, I believe they are, that Judge Freshour had assigned to me. So I now have all of those cases because I didn't have enough to do. So I have all of those cases. So where are we now on this, folks?
Your Honor, a few things have happened since our last meeting with you about 3 weeks ago. As Your Honor just noted, we did consolidate the cases. You might recall Mr. Carroll was getting whipsawed between the enforcement proceeding and the forfeiture proceeding, so we've addressed that issue. We also filed an amended complaint, and in this case, we're seeking that the Coxes actually pay the assessments that the township has made to clean up, and that's about $24,000.
Now, this case is much more complicated and much more expensive. The plaintiff's attorney is describing a long-running dispute involving municipal code violations and property maintenance problems, and according to the claim, the township had to step in and clean up the property itself. That cleanup cost roughly $24,000, which the plaintiffs now want the Cox family to reimburse. Here's how these situations usually develop. When property owners fail to maintain land according to local codes, things like excessive debris, unsafe conditions, or structural issues, the municipality can intervene. If the owner doesn't fix the violations after warnings, the local government can perform the cleanup and then bill the property owner. That appears to be exactly what happened here. But listen carefully to what the attorney said. This dispute has been ongoing for 4 years. That's a huge red flag in civil litigation. When problems last that long, courts often start looking for a permanent solution rather than temporary fixes. The phrase the attorney used, "put up or shut up," is blunt, but legally it reflects a real strategy. They want the court to set a strict redemption period, essentially forcing the defendants to either fully comply with property standards or risk losing the property entirely. And that raises an interesting question for viewers. If a property repeatedly violates maintenance standards for years, should courts eventually remove the owner from the property altogether?
And Your Honor, we filed a motion for entry forfeiture judgment, which is, we don't have a hearing date yet, but that is our effort to finally get relief here. I think the court is aware that for 4 years we've had this problem with the Coxes simply incapable, apparently, of keeping their property up to maintenance standards. Because of that, the township has filed several enforcement proceedings. That's resulted in costs assessed back to Mr. Carroll. And it's just basically a situation which we need to ultimately. So we have requested that in the hearing that will be before Your Honor when the court schedules it, so that what we're asking, and again, we'll argue this later, but we're just so the court understands, we're going to be asking for a redemption during which the Coxes can basically put up or shut up, because we just can't be in a situation where every 6 months we're getting sued again, and they're unwilling or unable to keep their property up to code. So we're hopeful that that will put the thing on a path toward either compliance by the Coxes or getting them out of the property. One or the other has to happen.
All right, Mr. Cox, anything you want to say?
Not specifically, sir, no.
All right. Well, I guess part of the issue, the property has been, I see Mr. Toth here, or Officer Toth. The property's been cleaned up at this point in time, correct?
Your Honor, if I might address that, Victor Lilick on
Okay.
behalf of York Township in those cases, Your Honor, the township cases. So it's reported as of yesterday that actually we did clean up the property, but actually it's reported as of yesterday, and we have some pictures that they are starting to accumulate junk on the property again already.
This is where the case starts to escalate. According to the township representative, the property was just cleaned up, but new clutter is already appearing again. If that's true, it becomes a serious legal problem for the property owner. Why? Because once a court order exists requiring cleanup or compliance, any violation of that order can lead to contempt of court. Contempt isn't just another complaint. It's a direct accusation that someone is ignoring a court ruling. And the representative just hinted at filing exactly that. A motion for an order to show cause and contempt. For viewers unfamiliar with that process, an order to show cause forces the defendant to appear before the judge and explain why they should not be punished for violating the court's order. If the judge believes the violation is intentional, penalties can include fines, additional court orders, or in extreme cases, even jail time. So the stakes here are rising fast. What started as a property cleanup dispute is now moving toward potential contempt proceedings. And here's something to consider. Property disputes often look like neighborhood problems on the surface, but once municipalities get involved, they can quickly become major legal battles.
We have judgment in the York Township cases. My intent at this time, Your Honor, would probably be to file a motion for an order to show cause and contempt for a violation of those orders. And I guess if it's possible, we would try to have those on the same date that Mr. Troika wants to have his motion date, Your Honor.
Good. I think that might be, I need a second sheet. Space. Okay. Mr. Cox,
Yes, sir.
are more things appearing on the property? I mean,
Absolutely not. I did know that that was going to be Mr. Toad's claim, because I saw him yesterday scurrying about. But it is, they did come and they did the clean. But I have, and I'm not done yet. I've gone through the property collecting what was left, and it's substantial. I was just trying to mow, and there's stuff that I'm not complaining about it, but there's just stuff that was all over the yard, and there's a lot of things that they did not take. So that's just me cleaning up my yard, and there is nothing new that's been brought to the property. That's just not true.
Now we're hearing the defendant's side, and it tells a very different story. Mr. Cox insists that nothing new has been added to the property. According to him, what officials are seeing is simply leftover debris from the previous cleanup that he's still working to organize and remove. This highlights one of the most common conflicts in property maintenance cases: the definition of cleanup. From a municipality's perspective, cleanup usually means the property must be fully cleared to meet local code standards. But from a homeowner's perspective, cleanup may mean sorting through belongings, salvaging items, or gradually restoring the property. That difference in interpretation can create ongoing disputes like the one we're watching here. But legally, the court won't focus on intentions. It will focus on compliance with the exact wording of previous orders. If the order required the property to remain clear of clutter, even partially reaccumulating items could trigger violations. So the upcoming motions mentioned earlier, especially the potential contempt motion, could determine whether the court believes Mr. Cox is genuinely trying to comply or deliberately ignoring the rules. And here's a question worth asking. If you were in Mr. Cox's position, trying to recover belongings after a forced cleanup, how would you prove to the court that you weren't creating new violations?
So I'm remaining in compliance as far as that goes. And I continue to, my attempts are still to clean the property thoroughly.
all right. Mr. Lilac, how long will it take you to file your motion?
Well, Your Honor, I can put that together today, probably.
Okay.
And get,
All
I
right.
mean, I think I could probably file that via email, correct? Is that acceptable to the court now? Or?
That with the court, if you send it to Ms. Weidling and then send it also to the clerk's office, that will be the actual filing of that.
All right,
14A office. And then, Mr. Cox, have you received a copy of the motion for entry of forfeiture judgment?
Yes.
Yes.
This is Laura Cox.
Okay, how are you going to answer that motion?
I guess I'm not sure how we do that, Judge Simpson.
Okay, you would have to file a written answer stating, in essence, answering the allegations put forth by the plaintiff and basically stating to the court what your position is on the forfeiture.
Yes, then we will answer that motion.
Okay, how long will it take you to file the answer to that?
7 days.
Okay,
I just want to seek counsel for that.
got it. I'm going to suggest to you, if you're going to seek counsel for that, that you also seek counsel regarding the show cause motions that are coming forth.
This moment is subtle, but it's one of the most important warnings a judge can give. Judge Simpson is essentially telling Mr. Cox, you need a lawyer, immediately. When a judge suggests seeking counsel, it's usually because the legal issues are about to become far more serious. And in this case, that makes sense. Between the forfeiture motion, the possible contempt proceedings, and the township's involvement, the defendant could be facing multiple legal fronts at once. Self-representation in civil court is already difficult, but when multiple motions are involved, especially ones tied to property rights or potential penalties, the legal complexity increases dramatically. Attorneys understand procedural rules, filing requirements, evidentiary standards, and how to challenge opposing arguments effectively. Without that knowledge, a defendant can accidentally weaken their own case simply by filing the wrong document or missing a deadline. Judge Simpson isn't forcing Mr. Cox to hire a lawyer, but he's strongly hinting that proceeding without one could be risky. And that leads to a broader issue in many courtroom cases, the imbalance between represented and unrepresented parties. When one side has legal counsel and the other doesn't, the courtroom dynamic can change quickly.
Okay.
Okay, thank you, sir.
All right. So I'm going to indicate that your answer to the forfeiture motion is going to be due. If you're going to get an attorney, I'm going to make that due by the 29th, by August 29th.
Thank you,
Okay.
Your Honor.
And then I'm also going to indicate that that's also to the forfeiture motion as well as to any show cause motion. So I'm building some time in there so that you can get those when Mr. Lilick files them, and all of those answers can be filed by that date.
Thank you,
You
You
Your
understand
Honor.
that?
Yes.
All right. Then what I'll do is I'll set a hearing. Let's give them Tuesday. Person.
Oh, Tuesday.
Okay, hang on.
Tuesday, September 5th, or I can kick it out further.
If they get everything into me on the 29th, but I got a holiday coming in there. What's our next date after that?
So after that, it would be Tuesday, the 12th
The 12th.
or the 19th.
All right. I can set a hearing on all the motions and the request for show cause, or the show cause and request for an entry of a other relief. I can set that for September 12th, if that would work with the parties.
Your Honor,
That's
that-
fine. What time, Your Honor? Because I do have a docket at 11 o'clock in front of Judge Freshour, I think.
Is that, are you doing that docket in person or?
No, that should be Zoom, Your Honor.
All right, so what I will do is I'll set this hearing on the motion for September 12th, 2023, 9 a.m. That will be in person here at 14A1.
This is the judge doing what courts call case management, and it's essential in complicated disputes like this one. Judge Simpson is coordinating multiple motions, multiple parties, and multiple legal issues into a single future hearing date. By setting the hearing for September 12th, the court creates a structured timeline for everyone involved. Notice what he's also doing behind the scenes, giving the defendant time to prepare. The judge allowed a period for Mr. Cox to find an attorney, respond to filings, and review any new motions that may appear. That's important because civil courts aim to balance efficiency with fairness. Judges want disputes resolved, but they also want both sides to have a reasonable chance to present their arguments. However, deadlines in court are not suggestions. They're strict requirements. If documents aren't filed by the ordered dates, the court can rule against the party that failed to respond, so September 12th will likely become the turning point in this case. By that date, the court expects detailed responses, legal arguments, and possibly evidence regarding the alleged violations. The question now is whether the defendants can prepare a strong defense before that hearing arrives.
There are rooms out here where you could zoom into Judge Freshour, and I'll accommodate that certainly for you.
Thank you,
Your
sir.
Honor, is there ability for us to attend Zoom because I will be in Illinois?
Somebody's gonna have to be here. Is Mr. Cox gonna be here?
I will be here and available.
All right, so you need to be here. I don't like to do that, Mrs. Cox, but I will allow you to appear via Zoom
Thank
as
you,
long
Your
as
Honor.
Mr. Cox is here.
I will be, and thank you for allowing her that.
Your Honor, did you say September 12th at 9 a.m.?
Yes, sir.
Your Honor, one other housekeeping thing. My client when he was without counsel, filed a motion against the township in the enforcement proceeding, which was scheduled for August 30th. We're going to withdraw that without prejudice at the moment, and I'm not even sure if that date carried over onto your calendar, but I wanted Mr. Lilick to know that he doesn't need to file a response and that we're not expecting a hearing on August 30th.
Right. Thank you for that, Mr. Trucker. The August 30th hearing, because the cases got transferred, that also got canceled.
Okay.
So we were going to reset it, but we won't reset it if you're withdrawing the motion.
Thank you, Honor. One last thing, I just want to be clear for the court and the Coxes that there's an order for them to replace siding on the house that's separate and apart from the accumulation of clutter outside. We'll discuss that on September 12th, but Your Honor should be aware that that still hasn't been done, and that is part of what will be before the court.
And that
All right.
will be a part of the show cause order too, Your Honor.
Yes. Okay. All right. We'll try to deal with everything on that day. All right, folks.
Thank you.
Thank you. You want this down?
Sure.
Kenneth McDade versus Frank Mead. And
Good
Marilyn.
morning, Your Honor. For the record, Stuart Collis on behalf of the plaintiff. Mr. Mead here, he's got on mute.
I'm not picking him up.
He was muted. He just unmuted, Judge.
Hello, Your
Oh,
Honor.
there he is.
I'm here. You were breaking up. I didn't know you wanted me to unmute.
Hello, Mr. Mead.
Hello, sir.
All right. This is a termination case. Mr. Mead, what's your position on the case?
Well, Your Honor, the reason for the hearing is to mention to you and to show you that we feel that we had earned the right to be in the home with all the expense and money that we have poured into it without any help from Ken, who owns the home.
This is a very common defense argument in tenancy disputes. Mr. Mead claims he and his family invested over $10,000 in repairs, including dealing with black mold and replacing flooring. His argument is essentially this: because they improved the property and spent significant money fixing serious problems, they should have the right to remain there. From a human perspective, that argument can sound reasonable. If tenants spend thousands repairing dangerous conditions, it might feel unfair to be forced out afterward. But legally, things are more complicated. Courts usually treat tenancy rights and property improvements as separate issues. Unless there is a written agreement allowing tenants to offset rent or gain ownership rights through repairs, the law typically views those expenses as voluntary. That's why Judge Simpson immediately redirected the discussion towards something called a counterclaim. A counterclaim allows a defendant to formally request compensation or damages within the same case. Without filing that counterclaim properly, the court cannot legally consider those repair costs when deciding the eviction. So Mr. Mead's story may be compelling, but unless it's presented through the correct legal procedure, it won't change the outcome of the case.
Now, a lot of these repairs had to be done immediately. We have literally spent thousands, Your Honor, and we have receipts to prove it, on that home that Ken owns. One of them was the fact that we've discovered black mold, which I'm sure you know is very dangerous. We had to replace all the floorboards and also we had to treat the black mold over a series of time, because you can't just simply spray it once and get rid of it. And it completely spread throughout the laundry room and the kitchen. Now, after doing all that, we had to reconstruct everything so far as the boards are concerned and the flooring. That all took time, and that took a lot of money. And again, we received no help from Ken. Now, we have receipts here, Your Honor, that amount to over $10,000 that we have actually spent in Ken's home without any help from him.
Let me just stop, sir. Let me stop you for a moment. Mr. Collis, well,
Yes, sir.
first of all, sir, with reference to those claims, you may have to file a counterclaim to any case, but I have a problem that I don't know if it can be corrected. And I don't know, Mr. Collis, if you see your notice to quit.
Let me see, Your Honor. The notice to quit was done in May, as I recall.
Right. Has there, I guess the first question I have is, has rent been paid since May?
Not that I'm aware.
No, sir.
Okay. The other thing that I don't have is, I don't have a signature on the notice to quit.
Ooh,
Now we've hit a technical issue that could temporarily stop the case entirely. The notice to quit is one of the most critical documents in eviction proceedings. It's the formal notice informing tenants that they must vacate the property within a specified period. But the judge just pointed out two major problems. First, the copy filed with the court does not show a signature. Second, it does not indicate how the notice was served to the tenant. Both of those details are legally required. Courts need proof that the notice was properly delivered, whether by certified mail, personal delivery, or another approved method. Without that proof, the eviction process may be considered invalid. This is why eviction cases often hinge on paperwork rather than dramatic arguments. Even if the landlord ultimately has a valid claim, failing to follow the exact procedural steps can delay or derail the case. Judge Simpson isn't dismissing the claim yet, but he is requiring corrected documentation before the court moves forward.
Ken said not to pay that rent, Your Honor.
Okay. Well,
I see on my copy, Your Honor, on the signature on the notice to quit. So I don't know why you don't have one.
I don't.
I mean,
I don't have a copy that has a signature on it. So
yeah, mine's scanned in with a signature, so I'm confused. I can't answer that.
Okay. I don't have a signature on it, but that's fine. I mean, I'll need a copy of one that has a signature
I can bring that by
on
today.
it. I think it may be because the other thing I don't have that has to be corrected, Mr. Collis, is the notice to quit is the wrong copy of the notice to quit to be filed with the court, and that may be why. The copy that needs to be filed with the court has to tell me how it was served, and this does not. I have the tenant's copy of the notice to quit.
I have it, and it's served first class mail. So
right, and I need that copy. So what I will do, Mr. Mead, are you going to have an attorney represent you on this?
Hopefully so, Your Honor. We haven't had time to get one as yet because we've only had it about a week. But,
okay, you'll need to get an attorney by next week. I'm going to adjourn this out to the 25th so Mr. Collins can get that paperwork into me and we can proceed on the case. So it'll be August 25th, 2023, 9 a.m.
Okay, sir.
The judge's decision here shows how courts handle procedural mistakes. Instead of dismissing the case outright, Judge Simpson adjourned the hearing to give the plaintiff time to fix the defective paperwork. This approach allows the legal process to continue while still enforcing proper documentation standards. Adjournments like this are extremely common in housing court. Judges understand that paperwork errors happen, especially when cases move quickly through busy court dockets. But the court cannot ignore those errors either, because eviction cases involve significant rights. Someone's ability to remain in their home. By scheduling a new date, the judge ensures two things happen. The plaintiff must submit the correct service copy of the notice to quit. The defendant has time to obtain legal representation. This creates a fairer procedural environment before the court makes any final decision.
And I need the service copy of the notice to quit with the court.
not a problem, Your Honor. I apologize that it somehow got disconnected.
25th at 9.
It happens. All right.
All right.
Thank you.
Thank you. See you next week.
Thank you, sir.
Rose Community Management versus Ron Johnson.
Thank you, Your Honor. Jackie Snyder, Porter, on behalf of the advisory.
I don't have an attorney either.
All right. And is Mr. Johnson here? You do not? Okay,
Yes,
I don't
I'm
have
here.
Mr. Where
I'm
are
here.
you, sir?
He's Samsung.
He's Samsung. Okay, you got it.
Yeah.
Okay. All right, this is a termination of tenancy case. Mr. Johnson, what's your position on the termination?
Actually, I'm willing to leave here. It's a very dangerous place to live, and I'm scared to death. So, I'm really trying to find me a
Okay,
place to live.
so
Yeah.
when are you gonna move?
I don't know. As soon as I can find me a place. I mean, this is all of a sudden. I mean, I was making a complaint to them about what was going on, then they turned it around and put it on me. So, I don't want to deal with that. They done that real wrong. I'm the
Sir?
president of the tenants association, and they asked me. Yes, sir.
If you're gonna leave, I just need to know when you think you're gonna leave so we can arrange a move out date.
Let's say within a couple months.
Well, I don't know that that's gonna work.
No, Your Honor.
Well, I'm dealing with Alex Henry at Legal Services, so he said just to take it to trial.
Are you gonna try it yourself?
Well, I'm gonna deal with Legal Services and find out if Alex Henry is going to continue to help me.
Your Honor, we received a message from Mr. Henry, and he indicated that he is not appearing at this time.
Today, yeah.
From
Not appearing. I don't know what there's going to be for me to try on this case. Are you disputing their allegations, sir?
Yes.
All right. I'll need a written answer from you within 7 days.
This is another key procedural step. When a defendant disputes a complaint, the court requires a written answer explaining exactly which allegations are being challenged. Without that written response, the court cannot properly evaluate the defense. Judge Simpson is giving Mr. Johnson 7 days to file that answer. The written answer serves several purposes. It clarifies the defendant's legal position. It prevents surprises during trial. It allows both sides to prepare their arguments. If Mr. Johnson fails to submit that answer within the deadline, the court could again move toward a default judgment, just like the earlier case we saw.
Do you understand that, sir?
Yes. What I'm supposed to answer what? What you want me to do?
Their complaint. You have to answer the complaint.
Okay. And then
I need a written answer within 7 days.
And I bring it to the court?
Yep. Bring it to the court, file it with us. We'll be more than happy to take it.
Thank you,
and if
sir.
you do that within 7 days, I'm going to set a trial for.
You want to do Tuesday? Yeah, that's fine.
I'll set non-jury trial in this matter.
Okay.
For September 5th, 2023, 9 a.m. That is in person.
Hold on, Your Honor. You said 9 a.m. on the 5th?
Yes, ma'am.
Okay, that looks like we have that date open. Thank you.
All right. Thank you, folks.
Thank you. Have a good weekend.
I will do. Court does call the case. Pension versus is it Koi Akipong?
Yes. Osei inside Caillou Ashumpong, sir.
Caillou Akipong. Okay. All right. Where are we on this case?
We are here for a motion for an installment plan.
Were the parties able to work it out?
I do not believe so, sir. Currently now, Osei, his wages are being garnished. Mine soon will be garnished, being a public school employee. I have yet to start back to work. And when work does start, those wages will be garnished. So we were hoping the court will honor an installment payment plan.
Okay, and what are you suggesting?
Well, $300 a month, $150 between Osei and I. So $300 a month.
All right, I got you. Okay, Mr. Mack, what's your position on that?
Yes, Your Honor, we filed comprehensive responsive pleadings in these matters. Your Honor, first of all, I'd like to bring to the court's attention that the motions that were filed were signed under penalty of perjury and sanction. And the motion that are filed are deceptive and an attempt in our position to deceive the court as to the actual incomes. Now, Your Honor, I have submitted a comprehensive series of exhibits under seal to this court to protect the privacy of the defendants in this case. As the court can see from the sealed exhibits, they have a sizable income that they filed with the Internal Revenue Service, Your Honor. They have a sizable income tax refund that they received from the federal government. They have bank accounts that they have not accounted for in their pleadings to you. Both of these defendants claim to be paying over $1,800 a month in rent, giving you the deceptive presentment, Your Honor, that there's $3,600 some odd dollars in rent being paid. That is a deception. They are not paying that in rent. But if you went by the face of their pleadings, they would try to deceive the court into that belief. They also, both of them claim to be paying a $31,000 debt on a Pacifica. Well, whatever debt they have, it is a joint debt. These are co-defendants, they're husband and wife. They filed joint income tax return. They have not been honest with the court as to their income. Mr. Asimengapong works part-time at TJ Maxx. He never included that in his statement. Ms. Asimengapong works part-time at TJ Maxx. They never included that in their statement. In terms of the bank accounts they have, they've never included those in their statements. One of them claims to have like $1.50 in an account. The other one claims to have like $118 or something in an account. But yet, from the evidence that I've submitted to this court, which has not been refuted, by the way, we see the U.S. bank account has got over $8,000 that was deposited in it. That has been never mentioned to this court. So these individuals are trying to pretend the pauper when they're really not. When they have bank accounts that monies are going into, though, that's income, Judge. And that's income that's going into those accounts after, legitimate taxes are taken out. So, Your Honor, we feel our pleadings are extremely comprehensive, and prove our case very well.
This moment introduces one of the most serious accusations in the entire hearing: deception of the court. The plaintiff's attorney is arguing that the defendants intentionally misrepresented their financial situation in order to obtain a favorable installment payment plan. According to the attorney, sealed financial documents show bank deposits, tax refunds, and income sources that were not disclosed in the defendant's filings. If those allegations are accurate, the court could view the installment request very differently. Courts rely heavily on financial transparency when deciding payment plans. If a party hides income or assets, the judge may deny the request or even impose sanctions. But it's important to remember that these are allegations, not proven facts, at least not yet. That's why the judge is moving toward a deeper financial review.
And we're asking for $500.
What do you guys have to say to that?
We gave Mac all of the documents that he has asked for. He asked for a copy of our tax return, which was received in maybe February. So if it says that $8,000 was deposited into that account in which Mr. Mac was given that information for, that money no longer exists. And I work part-time at TJ Maxx, and so does my husband. All of that information I gave that information to my husband to give to Mr. Mac. But we don't have that money. If the money was there, he would have been given that. Peter would have been given that. What we're asking for now is the installment because we don't have the money.
All right. Hold on. Hold it. Here's what I'm going to order. I'm going to order that the defendants are to file a detailed statement of monthly income and expenses with the court. You're to do that within 7 days.
Okay.
Everything is to be included on that regarding any income, any expenses. Since you're married, it will be, and this is a joint request,
Yes.
then it needs to be laid out in that fashion.
Okay.
And
Now,
then you need to file that within 7 days. I'll adjourn this hearing then till September 1st.
okay, sir. I have one more question. Is that okay to ask?
At 11 a.m. What is your question?
My question is it just like a Word doc that we set up with all of our expenses?
I want to see what money is coming in and what
Okay.
money's going out and for what.
Okay. Yes, sir.
All right. That
Yes.
needs to be filed in 7 days. Copy to Mr. Mack. And then I'll see you guys on September 1st at 11 a.m.
All right. Thank you, sir.
All right, Judge.
Thank you.
Today's courtroom session shows just how complicated housing disputes can become once they reach civil court. Across these cases, we saw several recurring themes: procedural mistakes, financial disputes, property maintenance conflicts, and the critical importance of documentation. Judge Simpson repeatedly emphasized deadlines, written filings, and compliance with court orders, because in civil litigation, those details often determine the outcome more than emotional arguments. In the Cox property case, the upcoming hearing may decide whether long-running maintenance problems finally lead to stronger court enforcement. In the Mead tenancy dispute, the focus will likely shift toward proper paperwork and whether repair expenses can legally be raised as a counterclaim. And in the Johnson case, the court will soon evaluate whether the tenant's safety concerns hold up once a written response is filed. Each situation reminds us that courtroom decisions rarely hinge on a single dramatic moment. Instead, they unfold through a careful process of filings, evidence, and legal procedure. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.